Welcome to the Millennial Lawyer Podcast.
Welcome back to the Millennial Lawyer Podcast. Today I'm joined by Brandon Finz, an attorney at Finz & Finz PC, a powerhouse New York personal injury and medical malpractice firm founded by his grandfather, former New York State Supreme Court Justice Leonard Finz, and now led by his father, the legendary trial lawyer Stuart Finz. Brandon is a Georgetown law grad who cut his teeth at Debevoise and Pimpton, representing the likes of J.P. Morgan, Blackstone, before making the leap on the plaintiff side to fight for injured New Yorkers. He's been named a National Trial Lawyers Top 40 Under 40, a Super Lawyers Rising Star, and has helped secure some of the top personal injury settlements in the state. Brandon, welcome to the show.
Thank you for having me, Mark. Very, very happy to be here.
Well, I'm excited to have you here because we've always ran into each other at different plaintiffs events and just events throughout the city and Long Island. And I know recently we were able to meet up for a lunch and to talk about your practice, and I was left so impressed by the wealth of knowledge that you have and the background that you have. But I really want to talk today about your $40 million verdict out in Nassau County.
Let me just start by giving a little bit more of an intro about the firm and who we are. We were founded by my grandfather back in 1984, former New York State Supreme Court Justice. He really paved the way for a lot of plaintiffs' firms back then. He was one of the most preeminent trial lawyers in the state at the time, getting seven-figure verdicts, in the mid 80s, 90s, before seven-figure verdicts were really a thing. He taught my father a lot of what he knows now, and my father, as you know, is now one of New York's top trial lawyers as well.
Absolutely.
The $40 million verdict that we received in Nassau County in late 2025, my father, Stu Finz, he was what people call the first chair. I was the second chair at the trial, and we tried that case over a period of almost a month. We prepared like crazy, as most trial lawyers do in the months leading up to the case. It was a very complicated failure to properly treat an ischemic stroke in a relatively young patient in his mid-40s at the time, which is young for a stroke victim. And I'm happy to go into as much detail or as little detail as you think is appropriate.
I remember from our conversation, you weren't even sure if it was really a case. And you had mentioned to me about how medical records, a lot of times they say one thing and it covers up what really happened. So walk us through when the case first came in and what your temperament was towards the case and what you guys were able to uncover during the investigation and intake process.
So, when we receive a new inquiry, all we're really working with is a story from a patient. And most patients really have no idea why something happened. It's really, all they know is that something happened. So in this case, it's a 45-year-old man who was left in a wheelchair with permanent paralysis on the left side, as well as some cognitive difficulty. And the family didn't know what went wrong or if anything went wrong. But he was hospitalized for an extended period of time after the stroke, had went through months and months of rehab. And once he had gone through the rehab, they decided to have a look at the case. They contacted us to see, was the treatment actually appropriate and could this have been prevented? So the first thing we always do when a call comes in is get the story from the patient, try to see as much as we can from the patient about what they remember, speaking with doctors, where'd you go, what facilities did you see, what doctors did you see? And then, of course, it's important to dive into the medical records. So in this particular case, as in any ischemic stroke case, and the reason I say ischemic is there are different types of stroke and not all strokes are treated the same. But when you have an ischemic stroke, which is a clot in a vessel, there are two potential types of treatment. One is called TPA, tissue plasminogen activator. The other would be mechanical thrombectomy. TPA is, if you had Drano, if your sink was clogged and you put Drano down the sink, it would chemically dissolve the clog in the drain and allow water to pass through. If you think of the water as the drain as a vessel and blood being the water, your brain needs a constant supply of blood in order to stay healthy, to stay viable. So for TPA, it can be a dangerous drug if it's not administered properly and appropriately. So there's strict limitations on when it can be administered. One is a time window. Back when this happened, the window had recently changed from 3 hours to 4.5 hours. That was the window from the symptom onset until you could administer TPA. In addition to that, if you were to perform a mechanical thrombectomy, that is a surgical procedure, brain surgery, where really a snake, if you were to snake that same drain, would be sent down the drain, and actually they would deploy a retriever to hold on to the clot and pull it out mechanically through the vessel all the way out through the femoral artery. And that also has a time window. So when we first got the case and we first got the records, we're going through thousands and thousands of pages of medical records. And in the records, it had identified that the reason TPA was not given was because the patient was outside the 4.5 hour window from the symptom onset until the time that he arrived at the hospital. As far as mechanical thrombectomy, by the time the patient was transferred, and he received treatment, or really no treatment, at 2 different hospitals. By the time the patient was transferred from the first hospital to the second hospital, the stroke had progressed so significantly on what's called a CT perfusion scan, just specialized radiology scan that actually maps the blood flow in the brain over a period of time, similar to a CTA, but much more advanced and much more detailed. Based on the CT perfusion scan, the neurosurgeon who was to perform the surgery determined that the stroke had advanced too far, and he was no longer a candidate for mechanical thrombectomy as well. So when we first got the records, and now we're going through to see what happened, what's the story, why didn't this person receive treatment, even though he was at the hospital relatively short period of time after the symptoms had started, it was clear that the analysis of the hospitals was that he was outside the window for TPA, and that the stroke had advanced too far by the time he was a candidate for mechanical thrombectomy. Therefore, he received no treatment whatsoever. And unfortunately, the stroke was left to progress, and he was left permanently paralyzed as a result. So on our initial review, there didn't seem to be a case. As a matter of fact, we have nurses at our firm who go through the records alongside the attorneys when cases come in, especially a potential high exposure case such as this one. And the nursing review and the initial attorney review was there is no departure from the standard of care here, which is what we would need to prove if we were to succeed in a medical malpractice case, because the hospital did everything right. Both hospitals did everything right. They called stroke protocol. They knew it was a stroke patient coming in. They got him to a CT scan immediately, and it was reviewed in short order, and therefore there was no case. However, when we took a deeper dive, as we always do, we started to learn that just because the record said one thing doesn't mean that's the be-all, end-all. And that really wasn't why he didn't receive TPA or mechanical thrombectomy. And actually, the analysis that was done at both hospitals was wrong. And we were able to prove that in court by jury verdict.
Wow. So going back to the nursing staff that you have, so how do you evaluate whether a med mal case is worth pursuing? Like, what's your screening process look like?
Sure. We get a lot of calls each year on med mal. More than you can count, really. And we have a triage team to look at every case as it comes in the door. Obviously, we're looking at 2 different components. One is liability. That's, was there a departure from the standard of care? And did that cause a patient's injury? And then we look at what is the injury? What are the damages? So if, we often get calls, I went to my annual physical, the doctor made a rude comment to me, and I don't really like him. I'm switching doctors. I want to sue him because he made me so upset. Obviously, a case like that, even if the doctor's not supposed to make a rude comment, there are no damages there. So we would not be able to pursue a case like that. On the flip side, you could have a catastrophic case such as this one, where a patient is paralyzed. And on that particular case, you know that you need to get all the records. You need to do a full, thorough analysis. We do our own analysis in-house based on a timeline of events in a stroke case, for example. And we do a lot of medical research. If it's a particular area of medicine, no doctor and no lawyer is going to know everything about that specific area of medicine. So sure, you pull experience from prior cases, and you speak with the nurses and you speak with doctors about particular fact patterns, but we do a major investigation before we take on any malpractice case to to make sure we have a full understanding of the medicine. What is the current state of medicine, because it's constantly evolving. And that goes to, you got to review the New England Journal of Medicine. You got to review the Journal of Stroke if it's a stroke case. You have to review the American Heart Association guidelines if it's a cardiac case, or believe it or not, a stroke case is also governed by the AHA as well. And you formulate your analysis based on all the available information that you can find in order to come up with a hypothesis. Was there a departure? If so, what was it? And did it cause a significant injury? And we vet every case like that.
I guess then, talk to us about like the expert game. So how critical is it with respect to lining up the right experts, and how do you find them?
So unlike a general negligence case, motor vehicle, slip and fall, trip and fall, you don't necessarily need to have an expert in order to put that case into suit. Some people do, some people don't. In a malpractice case in New York, an expert's required because you have to file what's called a certificate of merit with the court when you file your summons and complaint. The certificate of merit, in essence, says I consulted with a physician and I have a good faith basis based on the physician's opinion that there's a departure from the standard of care here. So if it's a cardiac case, we would, again, do our own analysis of the records, come up with our own hypothesis as to what went wrong and what should have been prevented. And then we speak with a cardiologist or a cardiothoracic surgeon, depending on what kind of case it is. If it's a labor and delivery case, we would speak with an OBGYN. If it's a stroke case, you got to speak with a vascular neurologist. If it happened in the emergency room, you need an emergency medicine doctor. So we line up our experts at the beginning of the case, not only to make sure that we are complying with the requirements for a certificate of merit, but also to make sure that we have a full understanding of the case, and this is our strategy, and this is how we go forward. Now, we do have experts that we use on a periodic basis, but it often does require us to find other experts in a particular subset of medicine. So we use different services for that. We speak with other med mal firms, regarding experts that they've used, and we do our own outreach, to certain experts to make sure that we're lining up the best possible fit for each particular case.
Well, what's the biggest mistake you see a lot of med mal lawyers make, especially the ones that don't have real experience in this space?
Sure. So that is a critical question because there's a lot of personal injury lawyers in New York. There's so many firms, more than any of us can even imagine. But there's a much smaller subset of firms that actually do medical malpractice. And even of those firms, there's a much smaller subset that do it well. Now, if you're a general negligence lawyer who does mostly motor vehicle or premises cases, you really shouldn't take a one-off medical malpractice case because it's a completely different animal. The quality of the defense lawyers, most of whom are seasoned medical malpractice lawyers in the business 20, 30, 40 years, they largely dedicate their practices to medical malpractice, unlike a general negligence defense lawyer who may do motor vehicle, slip and fall, trip and fall, lead paint, fire, with a variety of practice areas. Med mal lawyers, generally speaking, on the defense side, specialize in medical malpractice. They know the issues, they know the strengths, they know the weaknesses, they know how to properly defend the case, and they're much more aggressive, both in terms of discovery and depositions, and particularly at trial, in breaking down a plaintiff's case. So you got to be prepared for that. In addition, the costs involved in a medical malpractice case, a lot of lawyers don't realize. They have a doctor that they use for general negligence case. I'll speak with that doctor. If it's a labor and delivery case, they may speak with a pediatrician who they've used on an infant comp, or they may speak with an orthopedist. But it's critically important that you get the right expert in the right field for the right case, because again, once that case is litigated and once the discovery is finished and once the depositions are completed, 9 times out of 10 in med mal, there's going to be a motion for summary judgment. And those are very, very detailed motions going through chapter and verse of the medical record, and the defense will line up experts in every single discipline that you are alleging something went wrong. And these are generally top quality experts. I'm talking about, the head of New York Presbyterian emergency room or the head of Harvard Medical School. These are highly qualified, entrenched experts who will pick apart your case chapter and verse if you don't have everything lined up with your I's dotted and your T's crossed. So it's important that you understand the medicine, you understand the strategy, and you understand what the defense is going to be doing in order to properly maneuver around before you get to the summary judgment stage. That's putting aside before you can get to trial if you get over summary judgment.
Let's talk about jury selection. I picked a jury up in Orange County last April, and I don't know. I feel like some of these jurors, no matter what, when you're talking about a med mal case and a doctor and all that, it's very tough to convince them otherwise. Or am I wrong? I mean, what are you looking for when you're picking a jury? Because there are some lawyers that say jury selection is everything, is the most important thing. And we could all agree on that or disagree on that. But when it comes to a med mal case, I just feel people have certain notions about doctors and how they feel about these cases. And it's very hard to sway them one way or the other. So how do you deal with jury selection with respect to a med mal case? And do you think there's any merit to some of the things that I have just mentioned with respect to notions of jurors and whether they're for the doctors or they're against doctors no matter what?
Sure. So the easy ones in jury selection are, when it depends on what method you're using, but if you're speaking with a juror one-on-one and you say there's a medical malpractice case and they say, oh, well, I'm a doctor, or my spouse a doctor, or my cousin, and I could never find I can never find against the physician. Those jurors are easy. So they're off for cause. The harder ones are, I have a friend who's in the healthcare field, or my third cousin once removed is a doctor, and now you really have to probe to see, just because this person is saying that they'll be fair, are they really going to be fair? Because I think your concerns are valid, especially post-COVID, because the whole healthcare movement in COVID was, we're going to rally behind our institutions, our hospitals, our doctors, our nurses. They are on the front lines. And a lot of that is still embedded in our society. So it's important that when you're trying a malpractice case, you get a fair jury, just like in any case. But a lot of jurors do come in with preconceived notions that, look, I like my doctor. I couldn't imagine my doctor ever doing anything wrong. I go to him or her for advice on medical issues that come up. I see them all the time. I have a good relationship with them. You really have to probe into jurors that say things like that to make sure that they're not going to be biased. And likewise, if somebody has had an adverse event, with a medical facility or a provider, you really have to probe into that as well, because that the defense, once they start speaking with that juror, is going to be trying to pull that out of them and get them off the jury. So you want to be open. It has to be a natural conversation in a setting where they can actually open up to you, even though you only met them for just a couple of minutes, to get the best read that you possibly can.
That's a great point. That's a really great point. So, tell us about how you made the transition from working at a big law firm to now fighting for injury victims. Like, what made you want to make that switch?
Well, it was, I worked at a big firm for about 4 years, Debevoise and Plimpton. You mentioned it, in the beginning. I was a corporate lawyer doing, large scale transactions and things of that nature. I was working with some of the smartest people I'd ever met in my life, smartest people in the world. And I actually loved my colleagues. It was hard work, very tough work, grueling hours, unpredictable hours. But it never really gave me that self-fulfillment that I was looking for in a career. And growing up, around the dinner table, my parents and my grandfather, they would talk about these cases and the clients and how things were developing and how they could help certain people. And I thought, well, maybe that would give me that same fulfillment. So I started talking to my dad. We would, at the end of each year, we'd actually have an annual meeting. Him and I would go out to breakfast, and it would be solely focused on my career and what I should be doing going forward. And I used to, for a couple of years in a row, I'd say, what do you think about me joining the firm? And do you think it'd you think he'd be a good fit? And he would tell me about his trials and his cases and his clients. And even though it was really hard work, I could see in his eyes and his passion for really helping people. And ultimately, after, like as I said, about 4 years at Debevoise, I decided to make the transition, and it's been, we've been hitting the road ever since. I really have felt that fulfillment, not only working with family, which I actually love, and people were concerned about, working with
People
family.
people have the same concerns with me. You know
Yeah,
what? I
you
tell
work with your
people,
brother. Yeah.
I work with my brother, and I think it's a beautiful thing. And you spoke so highly about your father, your late grandfather, your mother, your sister. I think it's a beautiful thing. Yeah, it's different with respect to dealing with family, but at the end of the day, when you love each other and you trust each other, you get a lot farther than other people, I think.
Absolutely. So
Yeah.
yeah, I mean, look, you do it day in and day out too. It's great working with family. It's for us collectively, your firm and our firm. I think it's seamless for us. Not to say that it would be for everybody, but it works for us, and I do find fulfillment in the work that we do.
So, what was your role in the trial, second chairing your dad?
Sure. So we prepared together for months prior to the case starting. We worked, we outline every witness that's going to be taking the stand. We had 17 witnesses. He did most of the witnesses. I did some, in terms of cross-examination, direct examination, things like that. And we really, you have to develop a theme in every case and start building on the foundation of the theme. Our case was the theme of missed opportunities because there was all these moments where the patient could have received treatment and didn't, and we said that he should have received treatment. So, going through the medical record, again, thousands of pages plus tens of thousands of pages of treatment records, going through all the depositions, breaking them down line by line, categorizing them into topics and formulations of, lines of questioning for attack for the defendant doctors and their experts, finding as much information as humanly possible on the background of each defendant and each defendant expert that's going to testify. So much so that one of the defendant experts, they were flying in from Boston. He was, head honcho of his hospital. He had been one of the founders of CT perfusion technology, which is the type of scan that was at issue at one of the hospitals. And we set up this particular expert knowing that he had a prior relationship with one of the target defendants, the neurosurgeon, who he said should have done surgery and misread the CT perfusion scan. So we found all this information online. We did an article search, a PubMed search, where they had co-authored articles. They had been to the same conferences in different states, lecturing on neurosurgery and interventional neuroradiology. And so one of the things that we always do is we try to discredit the expert, get the jury to really not like this particular expert or this particular defendant. So as we're creating the outlines together, one of the formulations that we're coming up with is how important it is to be independent when you're offering your opinion as an expert. You should not have a prior relationship with the defendant because that could potentially influence your opinion on the case. And so now we've got the outline, and now the cross-examination is going throughout the trial. And doctor, it's important that you not have a prior relationship with any party in a case that you're going to be testifying in. Isn't that right? Oh, yeah, that's right. And that's because if you have a prior relationship with a defendant, for example, that could potentially influence your testimony. You could put your thumb on the scale of the defendant. Isn't that right? Oh, well, potentially you could. You wouldn't want that kind of situation. You walk him down the garden path, and then you start hitting him with, well, in 2016, you co-authored this article with him. Isn't that right? I don't remember. In 2017, you co-authored this article with him. Isn't that right? If you have the article in your hand, I must have authored that article, and so on and so forth. And so we started nailing him with every article that they had co-authored, every visit that they had been to together, every patent that they were both promoting at the same time, so on and so forth, to make it as if these two guys are so intertwined that he could not be offering an unbiased opinion. And I think the jury saw that and heard that, and we try to do that with every expert in every case.
Wow. So clearly it paid off with the
Yeah.
$40 million verdict, which Nassau, as some people know, it's a tough venue. It's not the best venue for any sort of plaintiff's case. You'd agree
Yeah.
with me?
I mean, look, historically, Nassau has been a tough venue. I think in the last couple of years, it seems to have been turning around. I've heard of other 8-figure verdicts in Nassau. I heard of an $8 million verdict just recently in Nassau in a malpractice case. So I'm hopeful that it is shifting more friendly to the plaintiff, but historically, it has been a defendant-friendly venue.
What advice would you give to a young attorney who wants to break into medical malpractice work?
A lot of lawyers don't do med mal. I think it's a great opportunity for a young lawyer to join a firm and learn the skill, because it is a rather unique skill set. I would say, try to find a firm, whether it's plaintiff or defense, where that would be your role, and actually dedicate your time in that role as opposed to trying to be a generalist and doing everything. If you're really interested in med mal, it's a fascinating field. It's a blend of medicine and law. There are opportunities out there. You just have to find the right firm. But study up on malpractice. Start trying to understand medicine as best you can. Start reading medical literature. Subscribe to medical journals, and learn as much as you can.
That's great advice. Because would you agree with me that since COVID, I guess the quality of healthcare has kind of declined a little bit?
I would say that. I would say that healthcare now is more fragmented than ever.
Yeah, right.
Because patient goes into the hospital. If they're admitted into the hospital, you get rounds from nurses, and the nurses they're working long hours, 12-hour shifts. They're seeing dozens, if not hundreds, of patients. When it's 4 a.m. and now there's a handoff, then the new nurse speaks with the prior nurse for just a couple of minutes to get an understanding of who this patient is, but they don't do a deep dive in the medical record. And the doctors and the different specialists, they come into the room for just a couple of minutes, they meet with the patient, that's about it. There's no real captain of the ship, so to speak, when you're in a hospital. And there's a real lack of communication amongst all the different providers. And one patient could see a dozen different providers in a single day in a hospital. And how are all those people communicating and making sure that the care is appropriate and fluid? And we see a lot of the time that it's not, because of that.
What's next for you? Are there cases or areas of law that you're looking to get into? Anything cool you're working on that you can disclose?
I mean, we've got a lot of cases coming up. We've got a lot of trials coming up this year. I'm hopeful that many of them will go if they don't settle.
God willing.
Should be an exciting year. Are we looking to expand into new fields? Not really. I mean, we have our niche. It's what we've been doing for the last 44 years, 42 years at the firm. I don't think that we're going to be moving beyond that, but we got a lot in the pipeline, and I hopefully have a lot of stories to share to come.
That's great. And I'd love to leave off again because you started with your late grandfather. I know that every time I attend a Brandeis Association event, he's always honored and spoken about so highly. So why don't you tell us about the Brandeis organization and your late grandfather's involvement with respect to the Brandeis Association and the legacy that he has left your father and yourself and your family in the future, as far as striving towards that legacy.
My grandfather was actually the founder of the Brandeis Association. It was when, there were several different, what I would say, affinity bar associations, but there was no real Jewish bar association, at least not in Queens. And my grandfather was a practicing judge in Queens, and he had lived in Queens and had a lot of contacts, friends, family, professional relationships in Queens. And he decided to form an organization to help foster, protect, and develop the Jewish bar and Jewish lawyers in New York. It's a great organization. There's a lot of lawyers who are involved with the Brandeis Association, thankfully. A lot of the judges are actively involved in the Brandeis Association, and there's an annual award, the Leonard L. Finz Award, that's given out to typically one judge per year at the annual dinner at the end of the year, in recognition of my grandfather's character and service to not only Jewish lawyers, but the bar of New York more broadly. It's a great organization. I highly recommend and suggest any lawyer who looks to get involved in Queens specifically, and certainly the New York City area, including Long Island, to join as a member of the Brandeis Association.
It's beautiful to see another law firm that has family roots, that has such a history, deep history. My firm's going to be 10 years old this August, so we're a baby compared to you guys. But
well, that's a great run, and your firm is in very much high regard with our firm. I think what you do is fantastic, and I really do appreciate you having me on and sharing our stories, and hopefully that relationship will continue. And I know that it will.
So thank you so much, Brandon. And Brandon, where could the viewers find you?
Sure. Best way to find us is probably online. Take a look at our website, finzfirm.com. You could also give us a call, 516-433-3000, or shoot me an email personally at bfinz@finzfirm.com. Anybody who wants to talk about anything, malpractice, general liability, family firm, life events, anything, I'm always available. And I'm at everybody's service.
That's great. Thank you so much. Thank you for listening to the Millennial Lawyer Podcast.
Thank you so much, Mark. Talk to you soon.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.